So it looks like we're ready to start. Okay, so as Karina mentioned, Robin and I, or as I want to mention, we're from Contra Costa County Superior Court. One of the things we want to note is that as we go through some of the material, some of these things are going to be how they're done are specific to our court. So if you have any questions, I mean, you can ask us, but you can also should probably make contact with people in your county who do similar type work, because how it's structured might be basically different. The material, how things are handled, it's in general is going to be the same, but just how they structure it might be different. And I said, my name's Scott. My background goes back to when I used to be a police officer. I worked both for a city and I was in military police. And I decided to go to law school for some reason and become an attorney. And I worked for 9 years in a sole practice in the area of probate and estates, including guardianships and conservatorships. I then took a position as a court investigator with Contra Costa County, and I've been doing that for the last 17 years.
And my name's Robin Taus, and I've practiced law for 40 years now. And I had my own practice for 30 of those years. And then I started working for the Self-Help Center in Santa Cruz and the one in San Benito County. And now I'm at the Contra Costa Superior Court. And I have to say, our court here has an amazing probate program. And in other counties, it's just anybody in the Self-Help Center helps you. Whereas here, they've specifically hired me to help for guardianships and limited conservatorships. And then I also do small claims, which is totally different. But so it's a very good program. And I do want to say, as Scott did, Contra Costa handles things different than other counties, which I know since I've worked at other counties. So it is, you need to be careful about contacting your local self-help center, and probably somebody there would be able to help you with guardianships.
Okay, so initially Rob and I were going to do both guardianships and conservatorships, but there was a lot of material for the guardianships. So if you have interest in conservatorships, you might let the Family Justice Center know, and maybe in the future we'll do a presentation on conservatorships. For now, I'll just say guardianship is different, is for a minor, conservatorship is for an adult. Now, guardianship is just one type of a child custody case. In family law, you'd have a child custody case where it's between the parents to decide who have custody of the child and what portions of the time. And then we have juvenile court. And juvenile court basically handles two cases: delinquency and dependency. Delinquency is when a minor's involved basically in criminal activity, and so they're going to court. They may get, probation, parole, those type things. That's all handled by the juvenile court under delinquency statutes. Dependency, handled by the juvenile court, that comes under Welfare Institutions Code 300. And typically this occurs where a child is either suffering or at risk of severe physical harm, emotional harm, sexual abuse. This might be from a parent, or it may be because the parent is neglecting to protect the child from this type of harm by somebody else. And under the dependency, there's guardianship. So that's like it's separate. It's actually under dependency. See situation, the social county or social agency in that county who's been assigned with the task to investigate these type cases will investigate these cases. In general, is Children and Family Services. That's the way I've seen it pretty much every county I've dealt with. When Children and Family Services gets a referral, they will assess to see if it meets the requirements on the Welfare Institutions Code 300. And then they will try to decide whether they can provide services. They might be able to just provide some help with bus, parenting classes, things that will help stabilize the family without the need of going to court. If they don't feel that that is going to work, then they can advance the referral to a juvenile dependency case. When a parent goes to juvenile court, they have the right to have an attorney appointed for them, and they have the right to a reunification plan, which basically means the judge just tells them there's certain things they need to go, take a parenting class, an anger management class, participate in drug rehabilitation, and whatever the judge feels is needed to address the issues that have been raised. And typically, if a parent completes that reunification plan successfully, they will have their child's custody returned to them. On the downside, if they don't do that, then they're at risk of having their parental rights terminated. And if they don't successfully complete the reunification plan, the court can order a guardianship under the juvenile court. Now, one of the differences is this guardianship by statute is supposed to be permanent, which means effectively the parents lose any parental rights that the court doesn't allow them to maintain. So sometimes they may lose custody, but still have the right to get records from the child's school, the child's doctors. But that's, again, by code that is permanent. I've seen a few of these cases where judges have terminated and gone back to a reunification plan. So it's going to kind of be dependent from court to court. Probate court, you have guardianships of the person and guardianship of the estate. The probate factors that we're looking at are pretty much the same as they are in the dependency case. They're generally just not as severe. And we're looking at the best interests of the child. Okay, so like I said, we had guardianship of the estate is where a guardian is appointed to manage the assets and finances of a minor. The guardianship of the person is everything else. And these can be awarded individually, or they can be awarded at the same time, both to the same guardian. And the guardianship of the person will cover things like medical, school issues, where the child lives, the support of the child, pretty much like I said, everything except financial. The difference between a probate guardianship and a dependency case is the probate court has no services. We can't give them anything. And we can't appoint an attorney to represent them, referring to the parent. We do appoint attorneys for the child. And we are prohibited from establishing any kind of reunification law. I mean, statutorily, we cannot say, okay, if you do this, this, and that, then we'll terminate the guardianship. It's kind of a subcategory of guardianship of the person is a special immigrant juvenile status. And this is a case which is designed to protect the minor while they're in the United States and give them legalize their immigration status so they can apply for residency in the United States.
So basically, a guardianship is when an adult who's not the child's parent is legally responsible for the child's care because the child's parent is unable to care for them. And basically what it means is that guardian or guardians has control and responsibility for the child. That includes decisions about medical care and school care. And that's very important because some of the schools will allow you to enroll the child with just a caretaker's affidavit but to be actually involved in any sort of special program for the child, you need to have a guardianship. And the guardian also can be liable for any damages that the child creates, which I don't see happen very often, but it is in the code section that they can be sued based on that. And a guardianship isn't permanent. I mean, Scott sort of touched on that, but at any time, someone can petition to terminate the guardianship. And that's usually the parents who feel that they are now able to take care of the child. So they petition the court and say it would be in the child's best interest to come back to them.
Okay, so when's a guardianship necessary? One case is where you have the absence of a parent. That could be both parents are deceased, or it could be where a parent is unavailable, typically due to, say, a military deployment, or they may just be going somewhere to work or participate in some kind of activity that it would not be a good idea for them to have the child around. The other is where the custody of a parent would be detrimental to the child. So guardianships are necessary when the parents cannot take care of the child. Some of the common reasons for that are homelessness, addiction, mental illness, or as mentioned above, their death. What I do want to point out is homelessness in and of itself is not a basis for guardianship. It's when that homelessness affects the parent's ability to care for the child that it becomes an issue. In addition, there are other reasons that would create detriment to the child, such as a parent is not able to provide for the child's basic needs or refuses to do so, or the parent or another person is physically, emotionally, or sexually abusing the child. Robin, you want to take the petition?
Sure. So who can petition for a guardianship? It's fairly wide open. It can be an adult relative or other adult or on behalf of the minor. What I see a lot is that it's the grandparents, the aunts, uncles, or sometimes siblings. And the siblings are usually when one parent is absent and then the remaining parent dies. So the siblings, they have to be adults, but they can come in and become the guardian of their brother or sister. And it can also be a godparent. I've had a number of them where it's been a person whose child was best friends with this child. And so they've offered and petitioned to be the guardian. And the proposed ward can bring an action if they're 12 years or older.
Okay, so who can nominate a guardian? There's two code sections. Probate code section 1500 refers to parental nomination and states that where both parents consent or nominate the same guardian, or where one parent's deceased or lacks capacity, then the other parent can nominate by themselves. Again, that's the statutory. As a matter of practice, I've seen it done otherwise with just one parent consenting. And that can happen in a couple of different cases, or one parent who wants to nominate a guardian. One would be the other parent just doesn't react, or they're not available, they're not contesting. The other is we'll oftentimes have the mother nominating a maternal relative and the father nominating a parental relative, where we have a contest between guardians. Probate code section 1501, first nomination of the guardian of a state. Parent can nominate guardian of the state, or the person from whom the minor receives property or their designee can nominate.
And so the process for obtaining a guardianship is detailed and it's complicated. But for the petition, normally it's filed in the city where the child's living. But there are exceptions, and the court can make exceptions to that. But normally that's how it's done. If the child's living in San Francisco County, it needs to be filed there. And when you're asking for a temporary guardianship, you still have to apply for the general guardianship. And that's something that people are confused about. But the temporary is really an abbreviated petition and information. So at the same time, they need to apply for the general guardianship.
Also known on temporary guardianships, to me, it's kind of misnamed. It should really mean like emergency guardianship. It's just there from the time the child needs until the general guardianship can be decided on. We don't grant like a guardianship for 6 months, for a year. The guardianships are indeterminate. They're there as long as they're needed.
And the process for filing the petition, there's two major ways. One is a computer program, and we've been very successfully using this in Contra Costa County. It's an LHI user-friendly computer program that's overseen by the Judicial Council. And it makes an amazing difference because it is user-friendly. People just have to go into the program and it asks them questions. And by asking them those questions, then it fills out the forms. And it makes it simple because there's 21 forms to apply for a petition that includes the temporary guardianship also. And There's 21 forms that are multi-paged, and that's if you have one child and one guardian. For every child that's added, there's 4 additional forms that have to be completed. So yesterday I helped some woman that was asking for guardianship of 4 children. And unfortunately, she didn't use the computer. So it was all having to be done by hand on the packet. And you have to put the children's name on every page. And so that alone takes you quite a while. And most counties, and Contra Costa does too, we have a packet available with the instructions and the forms. But if they can use a computer at all, I encourage them to do the LHI, because also what it does is once they get it done, there's a button on the computer where they can email it to me, and then I can quickly review it so that then they're ready to go on to the next step. And it makes an incredible difference. And I tell people, if you can order on Amazon, you can use this program. We get the few that, just aren't computer literate at all, and they don't have anybody to help them. So they do have to use the packet. So what they do is the process we have in Contra Costa County, which I think is a great process, is that once they have the packet completed, then they go to our probate examiner's office. And the probate examiners are incredibly helpful and intelligent, and they will review the packet and see if it's ready to be filed or not. And they will also tell those people what the steps are that they have to do for notice for a temporary guardianship. And then once those things are done, they actually copy all the paperwork for them. So when you combine the computer program with the probate examiners and all the work they do, it simplifies everything. But, I have to say, that's only in Contra Costa County. The other counties, will do different things. And if a temporary guardianship is requested, the hearing will be heard usually within 5 days, because what they have to do is they have to notify the parents that they're going in for a temporary guardianship, and a background check has to be run on the guardians. So that usually takes about 5 days. And if there's not a temporary granted, then it will be about 28 days before, it will be about 2 months before you actually get your hearing for the general. Oh, and so the next step is once all the paperwork is filed and the petitioner has picked up the packet from the clerk's office, they've put the hearing date on there, and then the petitioner has to go forward and notify all of the relatives in the second degree, which are the parents, the grandparents, the siblings, and the minor. And the service has to be done, like almost all services, by a third party. The petitioner cannot do it. And we often have situations where the petitioner doesn't even know the name of the relative, or they don't know the address. So in that case, they would have to do a declaration of due diligence, showing they at least tried to find out what the name was and then the address. And we actually have a form it's a local form that we use called a declaration re notice, and it takes them through the steps of looking as hard as they can for the person. And so that's used often. And then once notice is given, the court also will normally appoint an attorney to represent the child. It's not necessarily done for every situation, but I'd say here definitely for the majority of them. And that attorney is called Minors Counsel, and they're actually asked to do their own report after they represent the child, not the parents, and they contact the child, speak with them. They usually speak with the parents and the guardians, and then they provide a report for the court. And then there's also the probate investigation, which is much more detailed, and Scott will tell you about that. Oh, so I'll go ahead. So for the hearing, once everybody's noticed, technically an order could be made at that first hearing, but this rarely happens. And I try to tell people because they're disappointed. They think really the process can be done in 30 days. And it normally can't because there's reports that need to be done. And also some of the things that will delay an order being made are objections can be filed. And objections are often filed. And if someone thinks the guardianship isn't in the best interest of the child, they can file an objection. It's usually, and they have to do it here, they can appear in court and make their objection, but the court will require them to file a written statement also. And it's normally the parents, but it can also be other relatives or other people can file objections to this. And then we also have competing petitions, which those don't happen often, but quite often. I have one going on right now where the maternal grandparents filed the petition for guardianship, and the paternal grandparents also want guardianship. So they're filing competing petitions. It goes through the exact same process, the same reports are made, and then the court makes the decision. And other people will ask to request for visitation, and that will add. And normally what they do is if there's an objection, a competing petition, or request for visitation, our court likes to ask them if they will attend mediation, because a lot of these problems can be solved through mediation. And so that also delays things because they have to make the appointment and go to the mediation and hopefully resolve the issue or come up with some agreement that makes everybody maybe not happy, but content. And then the probate investigator's report is probably the most important part of this whole process, is because the court, the judges can't really know what's going on. So I'll let Scott talk about what he does as a probate investigator.
Let's finish up the hearing and I'll go over the investigation because that's pretty detailed.
Oh, I still haven't finished it. Okay. Yeah, there's the report of the minors council. And then before each hearing, our probate examiners prepare what's called a tentative ruling. And this ruling is very important because very few people get everything done. They always forget to serve somebody or they don't know how to do it. So the tentative ruling explains what still needs to be done before that next hearing so that the court can make an order. And then once everything's filed, the reports, all the notice, then the court can make an order. But if anyone, and this happens more than you'd think, if anyone requests a trial, they'll set a trial date. And the parties will be expected to, prepare their case. They can have counsel if they want it, but it's a regular trial that occurs.
Okay, so a probate investigator, in our county, the court, we work for the court. Many other counties, they work for the court, but I know in some counties, they may have an investigator, but they hold other duties such as mediations, maybe facilitation. They take on many hats, and other counties will put the process out to a vendor. So I use somebody from the outside, and they'll appoint them as a court investigator. I'm supposed to be a neutral party in the investigations. And while I provide information to the court and do take direction from the court, I have a separate office. And so the court really doesn't tell us what to put in our reports. And our recommendations may not be the same as the judge. Sometimes I make recommendations the judge doesn't accept. But that's the idea, is that it's a neutral perspective. Again, because the judge doesn't have an opportunity to go out and there's a lot of information they would not have if we didn't do an investigation. The main purpose of my investigation is, one, to determine whether or not a guardianship would be warranted, whether or not the person petitioning would be an appropriate guardian, and then if there's more than one person petitioning to be guardian, who would be the better choice. And occasionally you can't say anything. Occasionally it'd be like, either's fine. There's, you have parental guardians, paternal guardians, maternal guardians. They may both be just perfectly fine. And then it's going to be up to the court's going to have to weigh it and decide how they're going to proceed with that. So the first thing I do, I get a guardianship file. I review it to see if it's a relative or a non-relative petitioner. By statute, if it's a non-relative petitioner, the investigation is to be done by the social service agency that is designated by the county. In our case, is Children and Family Services. I know some courts don't do this. They'll just handle all of the investigations, but in Contra Costa, if I find a non-relative is petitioning, then we make a referral to Children and Family Services to conduct that investigation. Then the next, I'm going to look at whether this is just a parental absence issue or I have an issue of parental detriment. And I also look at whether it's contested or uncontested. Now, basically a parental absence, those are rarely contested. It's usually the parent is making provisions for their child because they're going to be absent. But the only time I've seen a contest is where a parent has to leave suddenly, and then they find out that the person who's petitioning to take care of the child is not the person they thought it was going to be, and it's not somebody they want to handle that. So they may file an objection, not to the guardianship, but to who's going to be the guardian. And even where there's parental detriment, I look to see if it's contested or uncontested, because in our county, we deem that if it's uncontested, the parent's not contesting, we consider that to be a placement with the guardian by a parent. And so since they are making arrangements for the child's care, there's no detriment. Now, where we determine this is a case, it's going to be contested. There are allegations of detriment by the parent. Then we'll make a referral to Children and Family Services because the juvenile court has priority of jurisdiction over the probate court. So we'll make that referral on a JV 210 form, that's a judicial counsel form, for Children and Family Service to determine whether or not they want to take this case and create a juvenile dependency case out of it. That doesn't happen too often. And so they'll generally send it back to us and say, no, we're not going to advance this. And as you may notice, one of the reasons is in the Welfare Institution Code, it refers to serious harm. So they may deem that this harm is not serious enough to be handled in that type of a forum, that it's better for it to be handled in probate court. Now, whether a case is contested or uncontested, I start with background checks. We use we call it CLETS. It's the California Law Enforcement Telecommunications System. I run a background check with that. I will get criminal history. I will get motor vehicle history. I will get history on not just domestic violence, but on restraining orders primarily. And then we also make a referral to the Child Abuse Index for the state, and that'll tell us whether or not there's been any convictions of child abuse by the proposed guardian. Now, in getting those background check, we also go to pull various records. So we will send a referral over to Children and Family Services to determine if there's been any referrals to them. If there have been, they may have either been advanced to an investigation or what they refer to as being evaluated out. So if they don't think it meets the Welfare and Institutions Code 300, when they evaluate it out, there's no investigation, but I'll still get information on what the allegations were and why they decided to evaluate it out. If there was an investigation, then I'll get a copy of the investigative narrative, so I have the detail of their investigation. And in Contra Costa County, all I get is from them are their records. However, they are part of a statewide system, so they will also tell me if there's an indication that other counties might have a record. And then I have to contact those counties individually to get those records. I will check with the school. And a lot of these things, what I'm checking for is dependent on what the facts of the case are. But in school, I'll be checking records such as what's their academic performance. So I'm looking to see Did they have a good performance? Something happened in the family and performance dropped off. I'll be looking at behavioral issues. And then I want to talk, if I can, to their teachers. There's a lot of stuff that's not reflected in those type of records. The child spoke to the teacher overheard them talking to other students, or the teachers observed things when parents come to the school. All that is useful information. And we also, if there's allegations of physical or sexual abuse, we'll check medical records. Medical records can mean the doctor, but it also can mean mental health records. And if they're in therapy, I can speak to their therapist. If there are, I'll know if there are allegations. Well, I'll get back to this at a different point. Okay, I'm sorry, getting ahead of myself. Okay, then we're also entitled to records from social service agencies. Typically, these are agencies to whom Children and Family Services has referred the family at some point, or the family may have gone to these agencies. These agencies provide various services, whether it's counseling, help with getting food, shelter, different types of things. But if they have any social service records, I'm entitled to get those. And then police reports. And police reports, I'm looking for a couple things. One is definitely any domestic violence calls that the police have been out on, because that will tell me things, not only is there domestic violence in the home, but whether or not the children were present during that time. I'm also just looking for a general background of, for getting more detailed information regarding arrests for drugs, violent crimes. And again, this is driven, what I'm looking for from the police reports is driven by what the facts of the case are. And ideally, I will have all this information before I begin my interviews. Realistically, it doesn't work that way. But I always start with the proposed guardian myself, because I want to see what are their grounds. And I don't just read I read their declarations, but I just kind of set those aside for the interview and say, hey, just tell me why you're petitioning for this guardianship. And that creates then sort of an outline for my further investigation. And then I'll talk to the parents, and I can contrast after talking to them about how they wear the guardianship, how do they feel about the guardianship. And then I can ask them about specific allegations that are being made by the proposed guardian. And there's a couple exceptions to this. One, if there's an issue of sexual abuse to the child, the county has a separate agencies that will do child interviews. And they have what's called a child interview center. And then the police, the district attorney, and representatives from Children and Family Services will be there. So we refer that. They will then do the interview with the child, and they'll send me the results. Another exception is if a child, at least in my county, is if a child is under 12 years of age, I'm not required to interview them. I can make that choice. And very often I don't, particularly if it's an uncontested guardianship. But sometimes, based on, again, on the facts, I might need to interview a child. I'm not going to interview them just to interview them. I'm going to interview them because I think there's some bit of information they can give me. Even children as young as 4 or 5 can be interviewed. What we usually do there is I'd start it just more casual. I'll ask them about things that they like, show me your room, get them involved, maybe playing some toys or drawing some pictures. And then I'll just generally talk about things. And first thing I want to talk about is trying to determine, can they tell the truth and a lie? How good of a reporter they're going to be. And I do things like a simple truth lie is I can hold up something with a particular color and say, what color is this? And they'll tell me it's blue. I say, well, if I say it's red, is that truth or is that a lie? We kind of test that wattage first. And then when I'm doing this circle around it, I just might talk, well, how's things, how doing in school? Do you ever get bothered by kids? Do some people do bad things? Does anybody in your house do bad things? And you kind of leave them out. They may make spontaneous statements that get you where you want to go. Sometimes you have to work at it slowly and just kind of edge in. As I say, it's kind of like, you put a frog in the water and you heat it up slowly and they don't jump out. The same thing happened with a child. You come in slowly and they'll get you that information. And sometimes it doesn't, but you do your best. And then again, driven by facts is whether or not I'm going to interview other parties, family members, their doctors, therapists, neighbors, staff at the school. Pretty much I'm going to interview anybody I think has information that would be valuable to determining whether guardianship is needed and who should be the guardian. Guardianships of the estate. We do the same kind of background investigation, except I limit it to the criminal history, and criminal history specifically looking for financial issues, issues of theft, issues of embezzlement, anything that might indicate that a guardian might try to defraud the proposed ward, might try to take their money for use as their own. The other parts we don't worry about because they're not necessarily placing the child with that guardian. And if we are placing with that guardian, then they're going to have a guardianship of the person. And then that warrants doing all the rest of the investigation. And now what we will do is we'll review the guardian's duties with them. The first thing we have to discuss with them is whether they are going to get a bond or use a blocked account. So a bond is kind of like insurance, so you have to pay a premium. And if there's a loss to the estate due to the guardian's inappropriate actions, then the bond company will replace that money to the estate. Although they will seek to get that money back or reimbursed from the guardian. Contrast that to a blocked account. In a blocked account, funds are placed in an account and the guardian does not have access to them except with a court order. So in the case where they put the money into a blocked account, basically my investigation can end right there under our policies. And I just notify the court the background check where there are any items of concern and note that they're putting it into the funds into a blocked account. Then the court sets a later date after if they grant the guardianship for that person to come in and show a receipt showing they filed it into a blocked account. Now, even that's all I am required to do under our policy. I do like to go over the inventory and appraisement and accountings with them. I apparently put accountings down twice, so it must be really important. The inventory and appraisement just is basically within 90 days of their appointment. They have to file an inventory of all the assets of the child that they have taken control of and give a value of those assets. And this becomes the basis for their accounting. So at the beginning, 1 year after they've been appointed, they have to file their first accounting, which will show the property on hand, which should match what's in the inventory and appraisement. Then they will show what amounts of new property or monies that have been received during that year. And will also show anything that they expended on behalf of the child. In a blocked account, they wouldn't have any expenditures again unless they got an order from the court authorizing them to do that. And let me kind of go back to that, some of the reasons for a bond versus a blocked account. A bond you have to pay for, so it's more expensive than a blocked account. But if they want the money there to be available for the child immediately, it's going to be much less hassle and actually less expensive than if they have a blocked account and each time they need money, they've got to go into court, request a court to allow them to spend that money and then take that order and go do the transaction they're wanting to do. So examples of when a bond might be appropriate is a parent is always required to provide support to the child, but all they have to do is provide those basic food, clothing, shelter type things. So you might have a child who's involved in sports or music and they need equipment. They go to special camps to get better at what they do. Or maybe you have a child that has a special medical need that's kind of above and beyond the parent's duty to support. Maybe they're going to need extensive, some orthodontic type work. All those things which are valid, it's going to be better for them to have a bond so they have those funds available and don't have to come to court asking permission to do that all the time. A blocked account is good, like where they're going to say, no, this money is going to go into an account and it's going to stay there till the child turns 18 and goes to college, and then it's going to be used for their college fund. So no sense of spending money on a bond, just put it into a blocked account. Noted, if it's in a blocked account, the guardian can still manage the funds. Now, if they put it into a savings account, they want to move it to a CD, they would probably not be able to do that without coming back for a court order because you're going to change the account number. But if they put it into an investment account where they can hold different types of assets, then if they move it from a money market to a CD to a mutual fund if the court gives them permission to do that. That doesn't require the court's involvement because it's all within that same account. They just can't withdraw the money, take any money out of that account. Okay, so now the last things we review for them are the obligations. So you have parental obligations to support the child. This is particularly important if they are the parent, and very often they are, because the funds that the child has are coming from some type of inheritance, maybe from a grandparent or the other parent. And so you have to remind them of things a parent is required to provide to the child, and kind of contrast that with the things that they're not required to provide and that they may use money for. And then finally, we notify them of prohibited actions, things that they can't do as a guardian, such as they can't buy a house with the child's money and live there unless they're also paying rent to the child's estate. They can't use the money. They can't take a loan from that money for themselves or for anybody else. They can't use the money as security for a loan. So basically, they can't do anything that might risk that child's money.
So there, as I said before, guardianships aren't permanent. They can be terminated. And it's limited to who can ask for that termination. It needs to be the guardian, a parent, or a ward if 12 years or older. So they petition the court to terminate the guardianship. And it's a fairly simple process in that there's only 3 forms required: the petition and the notice of hearing, because a hearing has to be set, and then the final order. I do suggest to them that they need to write a declaration, because what this will be based on is the termination in the best interest of the child. And often the guardian doesn't feel that it would be, and so there would be objections to that. And it's the same process where they have to notice everybody that was noticed for the guardianship. And if there is objections, then there would need to be a trial about that.
Okay,
But otherwise, it's fairly straightforward, and people do it multiple times. If they're denied the first time and then they become more healthy, I want to say, self-sufficient, able to provide for the child, then that's a time for them to try again.
Okay, so if the termination of a guardianship is uncontested, basically the guardian, parents agree that it should be terminated, then we will not do an investigation. The court, however, if it's contested, the court will refer the matter over to our office for an investigation. And it's kind of the same thing. We're going to, if necessary, pull the same records, and we're going to take a look, and we're going to try to determine if it's in the best interest of the child to terminate, or if the child needs to stay with the guardian. And we can also recommend sort of a hybrid that, well, it could be terminated, but maybe it's too soon, because one of the factors that weighs into termination is how long has the child been with the guardian. So the longer the child is with the guardian, the stronger the bond between that child and guardian becomes, and that becomes a factor in a termination. And so it might be something, well, we can't just terminate it cold turkey, as you might say. We need to transition the child to the parent's custody. So it might be making more visitation. Then the parent has custody of the child on the weekends, responsible for getting him to school on Monday, picking him up on Fridays, and just transition that time over until we say, okay, we'll have a review hearing. Yeah, this has all been going well, and we feel the child is comfortable in the parent's home now, and everything is ready to be terminated.
And there are alternatives to the guardianship. The one that I recommend most often is the caregiver authorization affidavit. It is limited to what can be done. It's a non-relative. They can enroll them in school and consent to school-related medical care. If they're a relative, then they can also have medical and dental care and limited authority over mental health care. And this caregiver authorization affidavit was designed by the legislation. And the interesting part about it is that only the caregiver signs it. So it's usually for people who maybe are only going to have the child for a short time. The other caveat to it is that the parent can revoke it and say that they don't agree with the caregiver authorization affidavit, and then it won't be in effect. And it doesn't affect the parent's decision or their rights as parents, but it does allow that caregiver to help in certain ways. And there is a power of attorney. I actually have never had anybody do this. But it's usually if the parent, and I think an example is if they're going, out of the state or out of the country, they can have a power of attorney written normally by an attorney to authorize the care of their child. And it gives much more authority than the caregiver authorization does. But the caregiver, of course, must consent. But it also means that they probably need some sort of legal assistance to do it, because we don't have a form or anything like that. And
yeah, these are a little more complicated. I've done a few of these. And whereas with other power of attorneys, you can go in somewhere and find a template to be used. Even statutorily, there's a template. These are not. So it does require a little more. And the other caveat is both parents, if they're available, have to agree. One parent can't use this as a way of kind of sidestepping family court and giving somebody custodial custody of their child.
Yeah, but if that parent has gotten full custody through the family law court, then I think they are allowed to do it on their own without the agreement of the other parent. And do you want to talk about the voluntary placement?
Yeah, I mean, this is one I have not had any experience in. I came across, but a parent can go to a child welfare agency under the code of the probation department, or if they're an Indian child, they can go to the tribe and they can voluntarily give up custody temporarily to one of these agencies.
Oh, and I should add, as far as the caretaker's affidavit, that does not allow that caretaker to apply for any sort of public benefits. And quite often when we have the person who's taking care of the child applying for a guardianship and a temporary guardianship, it is because they need those public benefits, either for housing or for medical care or for groceries. So that's one thing that the caregiver is not, the public agencies will not allow them to apply using just a caregiver's affidavit.
Okay, so these are just a couple of resources that you can check. These are judicial council forms. GC stands for guardianship and conservatorship. So when you go on it, once you what area of law, you have to scroll down to guardianship and conservatorship. And these just talk about some of these alternative methods and goes into a little more detail than we can go into here.
Right, and I would really recommend, if people are considering helping somebody apply for a guardianship, that the GC 205 is an excellent resource because it gives a lot of information on that. And then the GC 207 does do comparisons in a lot of detail.
Yeah, I think we made pretty good time. That's the end of our presentation. This is the contact information you have. I will note, please, that this is my business cell phone, my business email. Please only use this for yourself. Don't give it out to any clients. Such. This is just for you to ask questions from this presentation, or if something else comes up later in this and you want to contact me, I'd be more than happy to talk to you about it.
So mine is entirely different. Mine are the numbers and the email that I have customers call and email me. And people like you who are helping them are welcome to. I prefer my email because the phone is actually a voicemail. And we're a little short staffed now so that the clerks can't always listen to the emails immediately. But as far as listen to the voicemail, as far as emails, I'm more than happy to have people email me with any question they have, and I can help them and give them some guidance on what they can do.
Can I ask you one quick question? I'm so sorry. I know it's the end of the presentation. So what if a juvenile is incarcerated and the siblings want to request guardianship so that they don't need the juvenile's mother's permission to be able to say visit or, you know, make decisions for the juvenile? Is that how it works, or that wouldn't work?
Kind of depends on what stage of the process they are at. If they have just been detained, then that's going to be determined by Children and Family Service. Well, if it's a delinquency case, they'd have to talk to probably either probation department or district attorney as whether or not they're going to proceed with a criminal action against them. And then, but if there has been a decision like that, say they were detained and they were released, then it could be either a dependency case for Children and Family Services. If Children and Family Services declines that, then it could be a guardianship in the probate court.
Wonderful. Thank you so much for your time.
So once again, thank you, Scott and Robin, for this presentation. I would like to read some of the questions that were also in the chat. Definitely going back a little bit. One of the questions says, is there, give me one moment. Is this also the process for step parents?
No. The process for step parent adoption, and it's actually a step parent adoption, not a guardianship. So it is very different.
Okay, the following question says, what does proposed ward mean?
And this is, it's confusing for people because people don't normally use the word ward, but that is the word that's used to refer to the minor. And proposed means that the guardianship hasn't been granted yet. They're in the process. So they're the proposed ward because somebody's asking to have guardianship of them.
Okay, and then the following one says, is there a court fee to file any of these?
Yes, there is a court fee. There's both a filing fee and then there's also a fee for the probate investigation. But the important part is there's a fee waiver that can be applied for. And I don't know how many years ago it was, but 5 or 10, the legislation decided that the fee waiver is based strictly on the ward's income. It doesn't include the household they live with or the proposed guardians. And as I've found, it's rare that a child has an income that's sufficient to make it so that they can't apply for the fee waiver. And if the child or the child's parents are receiving any type of public benefits, that normally allows them to receive the fee waiver. And then all the other things that might include fees will be waived at that point.
Okay, thank you. And then I have this question on the chat that says, is obtaining a guardianship generally something that someone can do on their own, or do they need an attorney?
Okay, that's what I'm here for. So because the guardianships are very complicated and because private attorneys are expensive, almost all the counties have someone, it's usually through the self-help center, who will help with the guardianship filing. And so that's when I have people email me, I get in contact with them. I really, really, really try to have them use the computer program, but we will work with them on the packets. And I'm not representing them, but I can give them guidance on what they need to do. And I'm not like a private attorney who's going to tell them when their hearings or anything. They have to take a lot of initiative on their own. But I don't know what the percentage is for our probate court, But I would say people doing their own guardianships is at least 50%, if not 75%.
Okay, and then the following says, since guardianship isn't permanent, when the court grants guardianship, do they tell the grantor how long the guardianship is for, or until a petition to terminate guardianship is filed?
They don't give a deadline. It's
Yeah,
until a petition is filed.
when we advise them, when we do our investigation, it's quote indeterminate is what we say. So it's just there as long as it's needed. So that termination is going to be driven by facts and what's going on with the parents and the children.
Okay, what about claiming the child as dependent for income tax purposes?
I don't know the answer to that.
I'm going to caveat that I kind of know the answer, but I'm going to say you need to consult your tax professional
Yes.
on that one.
If a step parent can apply for guardianship, but they would be considered a non-relative, example, the child was living with dad and stepmom, dad dies, stepmom can now apply for guardianship?
Yes. I actually had one recently where, and I don't know why they were doing it, but the stepfather was applying for guardianship. His wife, the mother, was still alive and living with him. And it concerned me, but I'm not allowed to give legal advice, is that if he gets the guardianship, it means he really has control over that child, not the mother. But no, we have step parents applying, asking to be guardians, and they're just considered a non-relative. So it puts them into a different category for the probate investigation. And it also means that they have to notify the State Department of Social Services because they're a non-relative.
Okay. And then the final one I see in the chat says, are there any mental health resources available to children and youth?
Okay, there are, but not through the court. The court doesn't have any resources. So there are various social services agencies that may be able to do that. The county provides what they refer to as wraparound services. So they kind of look at all the needs of the family, and a guardian can apply for those services.
Okay. Those are all the questions I see out in chat. I don't know if anybody in this moment has another question that they would like to ask. And once again, like I mentioned at the beginning of the presentation, in case you missed that, this PowerPoint presentation will be emailed to everyone. I think there was a question there.
Are you done outside, sweetie?
Okay. So like I mentioned to everyone, the PowerPoint presentation will be emailed to everyone who registered for this presentation. And in case you have any more questions, their contact information is there. If there's no one else with any more questions.
Can I make one last pitch?
Yes.
I'd really like people to refer people to my office because it's much easier for me to get them started on the correct path than later on try to correct what was done, because they didn't know exactly what to do. So just feel free to refer people to me or to contact me yourself.
Okay, and once again, I want to thank you, Robin and Scott, for taking your time, giving us a lot of this very good information, very useful information. And I want to thank everyone else for attending the Zoom meeting today. If there is no more questions, I think we'll let you guys go a little bit early today, give you guys a little bit of extra time, but definitely enjoyed having you guys here and educating us.